Hi, welcome everyone.
Yeah.
I know, right? Wake up. Good evening. We have to keep it loud to keep this thing interesting today because we're talking about governance. No, I'm kidding. At least this is the more exciting one. The next one's on finance. My name's Kniazuk. I'm the Executive Director of Art Services Initiative of Western New York. And we're sort of the regional arts services group, arts council group. We provide professional development, grants, opportunities, and advocacy for cultural organizations and artists in 5 counties, as well as some public programming to increase access to the arts. Today's session is brought to you by our fine sponsors, the New York State Council on the Arts, with the support of Governor Cuomo and the New York State Legislature, Fund for the Arts, and the County of Erie, with the support of the County Executive and County Legislature. And the County of Erie, I wanted to leave for last on this one because they're a great partner to us in a different way. For those of you who were at the application briefing for the cultural funding application a couple weeks ago, you noticed that they identified a few different things that they found in last year's application that as a whole the field maybe needed a little bit of improvement on or a little refinement on. So they talk a little bit about what the field does very well, but then they also kind of identify a few items that they'd like to see us get better on. And they share that with Art Services Initiative and then ask us to hold one or a couple of training sessions around those topics. So tonight is the first of 2 that we're doing around those topics. And tonight's theme is governance. In a couple of weeks we'll be doing one on finance, things like balance sheet, cash flow forecast, common errors in tax filings. We're still setting that program because of course we only found out the topics a little while ago when you all did. But look for that probably the week of the 22nd. If you're on our Facebook page and on our website, asiwny.org, you'll get notice of that right away. We'll also send you an email out to previous year's funded organizations. And we're working on getting that program together. The goal then, as is the goal tonight, is to give you some very practical information, some information that you can take right back to your organizations and use, both for the application, but more importantly, to sort of get your organizations healthier as well, right? So, part of the reason we're talking about these things is because we need to be able to answer the questions on the county application and all the other grant applications we apply for. But really, the meaning behind all of those questions is that these are topics that are important for our organizations. And I think it's important not to lose sight of that because sometimes we look at all of these things as an onus. 22 essay questions on the county application, and you're like, oh geez, well we got to know this stuff in order to apply and get money. Well, yeah, but we also have to know this stuff because these are the rules under which we operate. These are the ways to make our organizations more high performing. And so we hope to leave you with things you can do, the meaning behind them, and then we'll follow up via email and also on our website with some templates and examples so that it's even easier for you to put these things in place. So before we get into the meat of this, the last thing I'll say is this, as all of our professional development and all of our work is absolutely free thanks to our sponsors, but we also have a big fundraiser coming up on May 10th, our 4th annual Spark Cultural Awards at the Hotel Henry. We're the cool kids because we're one of the first ones in there, so come see us before every other organization in the world has their fundraiser at the Hotel Henry. Information on that is at asiwny.org as well. So tonight, our main presenter is Stephanie Adams, and Stephanie is the legal counsel at Niagara University, is also the pro bono legal counsel for ASI, serves on many boards and community initiatives, and actually knows what she's talking about. So she's going to give you the main presentation, and then I'll add in some thoughts on the different topics of kind of practical application for your organizations. So with that, I'll get over to Stephanie, but you can call her Cole.
Yes. Hello, everyone. My nickname is Cole. My maiden name was actually Cole, so I found it hard to give it up as I made that decision to, go along with the patriarchy and take my husband's name. So my nickname is Cole, and please call me that, although my mom is always happy when people call me Stephanie. I'm not going to hold the room and really make us go around and do introductions. I'm sure a lot of you know each other. But I always like to go to presentations like this and make sure that at the end I've given people what they expected. So if there is a burning question or topic that you really want to have here as a takeaway, could you maybe just throw up a hand and say, you know, I really need to hear about updating our conflict of interest policy, or I really need to hear who in my organization should be our whistleblower officer, or if it's just everything you just said, you know, is really scary to me, can you please talk about that? That would be really helpful to me, because I'd like you to leave just feeling like you've got some valuable takeaway points and maybe what you came here to hear this evening. So what are people hoping for?
Will we share a question later on?
Okay. You want to share, you want to keep us in suspense?
I don't want to keep in suspense, just if we have questions.
Oh, no, yeah, absolutely. As questions arise, please feel free. And, you know, every year, so I was admitted to the bar in 2003, so every year I get more embedded in, I don't know, years flying, 2001. So every year I get more embedded in legalese. So also, if you're just like what you said, made absolutely no sense, please throw up a hand and ask me to not speak in Latin, and you know, I'll do what I can about that as well. Okay, I want this to be really useful and accessible, and hopefully you'll go away with some great tips for working with your boards, your insurance carriers, your assigned counsel, and yes, those very exciting people, your accountants, to manage all this governance stuff. So I guess with that, I'll start out and just say, I imagine most of you are 501c3 corporations, right? Registered with the Charities Bureau in New York State. I'm getting the nods. Excellent. Okay. So, pardon? Pending. Right. Okay. Or so yeah. Right. So you're on the road. So your 1023 has been filed, and you're just waiting to find out if the backlog at the IRS can get you through. I hear that they're going a little faster than they were a few years ago, which is good. Good. Okay. So one of the things that I would say as a tip is, as we start talking about the different filings and the policies, for those of you who don't have all of those things gathered in one place, what you might want to do is take the handout and make yourself a running checklist of what I would say you should have in a sort of Bible, right? Or take the theological text of your choice, right? And that should include, of course, your articles of incorporation under the state of New York, all right, which very much should have. And if you've all, or you're on the way to getting a successful 501c3, embedded in that incorporation document, for most of you it'll be the Department of State. If some of you are with a museum or affiliated with an educational institution, it might come down through the Department of Ed. So sometimes it's not the Department of State. But you'll have articles of incorporation that basically create your corporation. And a few years ago, there was a lot of buzz about the fact that a corporation is a fake person, right? But that's exactly what it is, right? The New York State not-for-profit corporation law, or the business law as well, creates an entity out of thin air because of the content that's in those articles. So when I was in law school, that was presented to me as sort of this magical thing, like, oh, we can create beings, you know, with the law. Very powerful. So that's a fundamental thing to have at the beginning, right? Because your mission should be in there, and everything should be consistent with that. And as we start talking about the different regulatory agencies that will be scrutinizing these documents and looking for reasons to deny you funding, right? Not that they would ever do that. Right, they're going to look for consistency with what's in those articles of incorporation. So I would call that your founding document. Yes?
I don't know if this is a stupid question, but if you change your mission or it expands, do you need to reincorporate?
That is not a stupid question. That is a great question. Generally, no. You can file an amendment, but the further you are into, I guess it's kind of like a relationship, right? The more committed you are to that particular identity, it would be a more complicated thing. So you'd be getting questions from different regulatory agencies like, why are you changing your mission? And the question would be right down to, are you expanding your mission? Are you merging with someone? Or did you used to be an educational institution and now you want to be a religious institution, in which case there'd be a lot of kickback on that. So that's definitely any fundamental change to the corporate purpose is something that really needs to be examined, and that is a board level question, right? So I think that's a really good question to bring up as we think about the foundation. Yes?
When you do amendments to your bylaws or anything, do you have to file them with anybody?
If you have to register with the New York State Charities Bureau, and most of you, I was looking at the list, probably most of you do, unless you're doing less than $25,000 a year. And by the way, this is all guidance that is on the Charities Bureau, and when I throw out numbers and things like that, those resources will be in the information that we send out to you. And then there's some specific exemptions for religious and educational institutions and some others. But if you have to register with the Charities Bureau, you at least have to be, you'll send in a copy with your annual statement. Yes, yes. So, so the first thing again would be whatever is this magic document that makes your entity exist, right? That should be first and foremost. And that's different from your bylaws, right? It's your articles of incorporation, your constitution, your founding document, right? And then the second thing that I would advise that you have in that packet would be the bylaws, because they're really the rules by which your organization has said, this is how we're going to conduct ourselves. And those bylaws, and I'm not going to go through all the things that should be in the bylaws, but if there's a specific category we want to focus on, I can certainly do so, right? But those bylaws will really give you the template for your operating. So, you know, we had an interesting one, ASI was being formed. That was a really interesting experience because, you know, we came into being. Maybe you could talk a little bit about that.
Yeah, I mean, you know, ASI is only 6 years old, not quite. And so the bylaws that were being put together, and this is, I think a theme that I'm going to come back to a few times is when you put things in your bylaws, when they go in your bylaws, then you have to do them, right? So when we fast forward in this conversation to things like committees and things like that, just remember me saying that if they're in your bylaws, then you have to do them. Because if you're not doing them, then you're out of compliance with the rules of your own operations, right? And so ASI's bylaws, when we were created, we actually made a mistake, right? You know, so we're Art Services Initiative of Western New York. And instead of just saying Western New York, it specified the counties. Except it specified too many counties. Like, it wasn't actually what the organization as it was being created intended to do, right? And so we have to go back now as part of our strategic planning process to correct that, right? Because even though nobody's really banging on our door and saying, you know, hey, why aren't you doing this, right? I mean, there's a fundamental disconnect between who we really are as an organization and what our governing document says we are. And so we're correcting that as part of our strategic plan, but again, kind of coming back to that, remember that if it's in your bylaws, you have to do it, right? So, or you've got to change your bylaws at some point. So, I don't know if that's the story you wanted me to tell, but that's the one that came to mind.
I think it was a good story. It was a good example of just, you know, reading them.
Right.
You know, you shouldn't be the only one in your organization who reads the bylaws. There should be at least 3 nerds within your organization, and one of them mine, right? Who knows the bylaws? Believe me, at certain rare moments, it will make you a superhero because everybody will sit there in the room going, what do we do? And you will know because, you know, every 6 months or so you revisit the bylaws and just take a look at them. There's a couple things that do need to be in the bylaws that I'll mention, and it really dovetails into our next piece, which is you should be thinking about what committees you need to have standing committees that actually are enshrined within your bylaws. And a couple of the policies we're going to talk about, namely your whistleblower and your conflict of interest policy, will likely rely on you creating some type of a committee called an audit committee. Now, you still don't have to have an audit committee, so under the law, you could just basically designate your entire board as a standing committee that takes care of audit and risk issues, right, and conflict of interest. But really, especially if you have a larger board, that can get very unwieldy because these are people who deal with highly complex, controversial, probably matters that you want to keep very confidential. So let's talk about the role of an audit committee, right? And one other committee that I would advise you have would be an executive committee. An executive committee is a committee that, of course, is empowered to act as the board if the board cannot convene, and then their action can be ratified at the next board meeting. It gives your organization flexibility. Other than that, unless you really, really need to have a committee mentioned in your bylaws, my advice, which might not work for the specific situation you're in, but to be as flexible as possible, you really don't need to have any other standing committees that are actually written out in your bylaws.
And now,
Aren't the officers automatically in part of an executive committee?
They'll function as an executive committee, yes.
and now to kind of take that committee conversation kind of, before we get to sort of the specifics with like audit and such. So one of the changes under the Nonprofit Revitalization Act is the way we refer to our committees now. So the kind of common parlance, and I do it too, I slip right into the old standing and ad hoc, right? But what we used to refer to as standing committees, the things like the executive committee, the audit committee, maybe governance committee, right, are now committees of the board. So that's a change that if you haven't made that change in your bylaws, that's a really easy way for someone reviewing your bylaws to know that you haven't, made some changes related to your Nonprofit Revitalization Act. So those are committees of the board. The old kind of
The audit committee and the standing.
the audit committee, the executive committee, so the things that we used to refer to as standing committees
Okay.
are now called, so instead of calling them standing committees, they're now called committees of the board. The reason they're called committees of the board is because, as Cole mentioned, they're committees that can in some way kind of bind the board to action, right? So that's why they're committees of the board, because they're sort of acting on behalf of the board. The old, ad hoc committees are now called committees of the corporation. So that's any of those other things, marketing, development, facilities committee if you own your own building, any of those kinds of things. And those committees are called committees of the corporation because they're really just things that are meant to help your corporation do its work, right? So committees of the board, kind of representing the board, acting on behalf of the board. Committees of the corporation, helping the corporation do its work. Those are the ones that, and again, going back to the theme, that if it's in your bylaws, you have to do it. So we see bylaws a lot of times where they say, well, because it's important to us to have a development committee. So we're going to put that in our bylaws. And we're going to put a marketing committee in there, and a facilities committee in there, and 25 other committees in there. And then some of them don't meet for a couple of years. Well, whether you know it or not, you're kind of then out of compliance with your own bylaws. So there's kind of some standard language about the ability of the board or even the board chair or president to sort of create other committees as needed. That language being in there kind of covers you. Then there's kind of like, taking it away from bylaws, there's sort of the newer model of instead of creating a bunch of committees that are just going to keep meeting every other month for the rest of eternity, right? You think about the tasks that you need to accomplish. So again, thinking of committees of the corporation being things that help the organization do its work. Well, what work do you need help doing? If it's periodic revision of your website, that committee doesn't necessarily need to meet every other month for the rest of eternity. Find a few people that can help you on that task. Get them together to do that task, and then let them go home and rest for a while. That gives you more of an ability, chances are, to recruit those people, because you're not asking them for an obligation in perpetuity. You're asking them to help you with one thing. We have a special event we need to do. Let's get some folks together and do that special event. We'll have one more meeting after it's done to close it out. Then thank you all for your help, right? I mean, yes.
So this is interesting because I'm actually going to offer a practical tip though,
Sure.
right, as opposed to the law. So one of the things I've observed is that people do like to be in charge of something, right? So if you have a board member and they dearly want to be in charge of the events committee, right? And they would take it personally if these committees were to be retooled or eliminated or somehow de-emphasized. There are ways to make sure that the board operations and this, committee of the corporation, or call it what you will, right? That's one way to achieve that. So, working with the attorney that you select to help with any kind of revision, right? We're trying to work with a group to make a change. You can come up with other ways to do that as well, right? So, if you get resistance, there's some ways that you can make sure the bylaws are easy to follow, updated for the Not-for-Profit Revitalization Act, but also are lending themselves to people being able to have that ownership of, I'm in charge of the acquisitions committee. That's fine. The acquisition committee doesn't need to be stricken from the record so that you can be compliant with New York State.
One other practical piece coming out of the Revitalization Act on committees is the idea of who can be on these committees. And for the committees of the board, it has to be board members. So, no outside folks. Those have to be your board members that are on that. I mean, obviously staff can staff those committees, right? But you can't have other folks on those committees. The committees of the corporation, you absolutely can have other folks on those committees, and probably should, because that's a great way to test out folks who like your organization and might want to get more involved. And instead of running out and putting them right on your board and 6 months later realizing this wasn't a great fit, you know, a committee is a wonderful place to test them out and get them involved. So again, that basic difference, committees of the board members only, committees of the corporation, you can have non-board members. You know, probably a good idea to still be chaired by a board member for that continuity, because those committees are reporting out back to your board meetings, and of course you want someone who knows what they're talking about to report that back out. But definitely get other people involved in those.
And also, and this is where your conflict of interest policy comes into play, certain functions can only be done by independent directors. And that really means that the director cannot be married to or have some type of relationship with the operations of the corporation. So, you know, at Niagara University, for instance, we have had trustees in the past who've been married to employees, so they would recuse themselves from voting on the annual budget, and they would not perform functions where it required an independent director, right? So, yes?
So, just a general question, because Todd, you already said a couple times you're sort of out of compliance if you do this. Where's the liability of a volunteer board member? How much liability is there if there's not following their own bylaws unintentionally, I would assume, because and puts them out of compliance? If that's challenged because of a decision that might be made that someone doesn't agree with and might cost the organization a certain amount of money, where's the liability of a volunteer?
Can I answer that? I guess that would be talking about DNO.
Well, so you're referring to directors and officers?
Yes.
So you have coverage for
Certainly,
it.
right, right. So a couple things, right? For the most part, there should be a part in your bylaws that covers the indemnification of your officers and your trustees/directors, right? And so that would be saying anybody who's acting in good faith in their capacity as a leader of this organization, as long as they're actually acting according to the rules, right, and they're doing their job, and they aren't acting, with criminal intent, and there's a bunch of exceptions, and a lot of this is governed by your insurance policy as well. And we're going to talk a little bit more about making sure you delve into those things a little bit later in the presentation. As long as they are acting according to their duty and they are following the rules, if there is some type of liability, then the corporation should have indemnified them, meaning they will give them a defense and the insurance carrier will step in and defend them, right? And so it's the difference of if my board passes a policy that one of our employees decides is discriminatory for whatever reason, and decides to file with the New York State Division of Human Rights or the EEOC, et cetera, right? All of my board members individually, even if they are named in an action, they will be defended by the institution. If, however, one of my board members is leaving a meeting and someone mouths off to them and they punch that person right in the face, they will not be indemnified whatsoever unless there's a rule in the bylaws that says, we'll take out the SAS mounts. There was a question.
Yeah, I mean, so your examples are great, but those are pretty black and white examples. And maybe I heard his question a little differently. What if it's an issue of like de jure versus de facto or something where like it's not on its face a violation of anything and nothing comes out of it, but you're like unwittingly, you're in fact violating your own bylaws, but you're not actually, like, the IRS isn't coming for you right away. Like, at what point, how deep, is that kind of what you were asking?
It's certainly unwittingly making a decision that might have a negative outcome.
Right.
Somebody then takes exception.
So yes, so you've asked a lawyer question, so you're going to get a lawyer response, right? So it
lawyer
depends.
question too.
It really depends on who is bringing that action. So if you, for instance, my example where you have a plaintiff who's an individual, right? That's different than if you have a regulatory agency. So for instance, the IRS or the Charities Bureau that's coming in to do an audit, right? An audit, they're going to look at your audit committee, first of all, right? And they're going to look and they're going to see, was this board asleep at the wheel? Were they paying attention to things? Did they make sure that their bylaws were updated according to the Not-for-Profit Revitalization Act? Did they make sure that they had insurance to live up to the indemnification clause? I've even seen, there's case law out there. Did someone properly second a motion when they put it up?
Oh, really?
Right?
So they'll look that deep into
So it depends.
Okay.
Yeah, there's a phrase out there in the biz, you can sue a ham sandwich,
Yeah.
right? And so if people will literally try to find any reason to complain. which is one of the reasons why, when I come back to talking about this compilation of information that, you're gonna be gradually putting together these layers of documents and making sure they're all consistent, having those things together and looking at them once a year or as the law is updated and making sure they're internally consistent is what's gonna save the day. And just to give you a little example, I know there's another question out there and we'll hit that in a minute. So one of the things I do at the university is I conduct due diligence when we're considering contracting with an agency. Whether we have a ton of subrecipients for the state and federal grants and private grants that we get. And if you've ever gotten, a response from, a place that said, well, we would love to contract with you, but we took a look and you don't have a policy on your website about, using minority and women-owned businesses. You have clearly not made an effort to recruit from a diverse representative body of our population here in Western New York to assemble your board members, right? We're looking at all those things. Those are the kinds of things that, I would look at when I conduct due diligence. Or the first thing I do, honestly, is I look at the New York State Department of State listing for those companies to see, do these people exist? Have they been keeping their filings up to date? I call it creeping on them, right? I look at their Charities Bureau filings. I look to see, are they gonna be a good partner? Because clearly they keep their stuff really well organized. And so aside from, if there's an internal dispute, so sometimes you'll even have board members square off with each other about failure to abide by board policy, let alone attacks from the outside, okay? So you'll have board members attacking actions that were taken by what was presumed to be the majority of the board. But then it was found that they didn't follow their own procedures, and no one could show that, whatever action it was that was in controversy was actually legitimately taken. I was at an event once where a general counsel at the event found out that her board had fired her president, who was her boss, and her boss was calling her to get advice to see if they had the authority to fire him.
Nope.
And she at the time was like, I don't think you're my boss anymore. Right? Most metaphysical thing. And the poor, she didn't have her binder of stuff to be able to check and see. So, I'd love to give you a very, very clear answer. Unfortunately, the best answer I can give is that by having these things very clear, routinely updated, and consistent from one place to the next, nobody can raise the question.
Right.
And that's the best place to be.
Right.
I'll give you a couple of examples from the review of the county applications over the years that are not as legal and as specific as what you've just suggested. In looking at the 990s, and we look at board chairs who sign them, and it says that to the best of their knowledge, all the information is accurate and complete, and they're under the penalty of perjury if the information is not accurate. As a volunteer who's reading your applications, I know that information is not accurate. I would like to contact your organization and say, your board chair could go to jail because you've not filled this out correctly. So that's one place I'd be very, very, very careful if I were a board chair in your liability exposure. Another example might be that Erie County may want to do a clawback from funds that were awarded in a prior period because you said you were in compliance. That your Charities Bureau information is up to date, that you had paid your taxes, that you had done withholding, all this kind of stuff. And then to find out later that that's not true. That is an example. It's not legal. It's not the black and white scenario that was suggested before, but that's a reflection on how good your record keeping might be or not. One of the examples that the board wrestled with a couple years ago was that an organization provided no services to the community, but accepted $30,000 from the county, and the taxpayers got no benefit from that grant. Should there have been a clawback that year? Right? They're all taxpayers. That's right. Okay?
And, and one thing, on sort of the practical application of this, all of this stuff speaks to why it's so important to have board members who are interested in these sorts of things, right? This governance is a cornerstone of what serving on a board is all about. And, a lot of times our board members, one of the main reasons, and this is wonderful, this is good, one of the main reasons they want to be on our board is because they believe in the mission of our organization. Well, that makes them great to be of service to our organization. But there are many ways to be of service, right? A volunteer is of service. A committee member is of service. A board member is of service. And those are all actually just as valuable. because they're all pushing forward the mission of our organization. But if you serve on a board, you have to be specifically interested in the governance and finance of that organization. It's not enough to want to spend time at the meeting saying, you know, I went to a board meeting of an organization, and just before I came on to speak, they spent 20 minutes talking about the color of merchandise that was going to be in their gift shop. And I'm like, man, that's like having dessert without eating your peas. You have to eat your peas. Like, did we spend any time on governance or finance before we got to this 20-minute conversation about the color of the merchandise in our gift shop, right? So that has to be the part. Now, as staff, and I assume most of you here are staff of your organization, we can remind, we can encourage, you know, at the end of the day though, the tricky part for us is that a lot of the things we're talking about are board issues. And so it's our job to kind of continue to encourage and remind and such, you know, but there we really just have to, I think, you know, convey this information, be very clear with our board, with our executive committee or governance committee, and really just kind of continue to explain to them. Kind of almost, I was going to say off the record, but we're being filmed.
Yes.
I use these sorts of grants all the time as an excuse to push forward these issues, right?
Okay.
Erie County is going to ask us about this in the next application, so I need my board to be thinking about this. So it's not me saying it for any other reason. It's like, hey, you want me to go out and get money from these folks? These are the kinds of things these folks are asking about, so I need to make sure I have an answer. Great way to do it.
So one of the other points I wanted to make is some of the applicants to Erie County have said that they do not specify in their bylaws that the board has to meet at any time during an annual year, fiscal year. How do you get chartered in New York State having 0 meetings of the corporation? So those are the kinds of things that you should be checking because your bylaws are your protection in a time of trouble. When things are going swimmingly, nobody's reading the bylaws. But then the you know what hits the fan, and then you go to the document and it's silent on the situation that you need help with. So looking at them now in a time of surety and things are looking okay, and you've got good governance and a good board and good management, etc. This is exactly the time to do your housekeeping and clean up your bylaws, making sure that your documents talk to each other, they're consistent, and that they answer the questions that you want.
And that checklist, by the way, is on the Charities Bureau
Yes.
website, and there's additional information on the IRS, and all those links are going to be in the materials that you'll have access to after the presentation. So don't worry about memorizing or writing down everything we say. I do not have them all. Actually, I might have them all memorized, but I'm not going to make you
Please don't.
listen. Right, exactly. That would get very tedious. Some of the powers of words.
So we were talking about committees. I want to make sure, I understand we want to take as many questions as we can. I also want to make sure that we stay, we promised you a certain set of deliverables. So we were talking committees, and Cole, you were about to talk about audit committee.
I was. All right, so your audit committee has become very important because it should be the designated place where you're required, now, some of you might not be required, but my advice would be everyone should have a whistleblower policy. So the precise criteria for having a whistleblower policy, again, you can do the diagnostic materials on the Charities Bureau's website, you'll be able to do that checklist. Basically, if you're bringing in more than 25 grand a year, pretty much consider that you have to have a whistleblower policy. And why is that? Oh, yes?
Every applicant for Erie County funding has to have a whistleblower policy.
There we go. So,
I understand.
and then she said, every applicant for Erie County funding has to have a whistleblower policy, and there's a really good reason for that. And it's because a whistleblower policy and all of the protections that are in there by law for people who are detecting fraud and abuse within your organization is a wonderful way to nip problems in the bud. It's a fantastic tool for risk management within your organization. And essentially, a whistleblower policy is something that gives a reporting mechanism that must be monitored by your audit committee. Okay, so accountability goes straight to the top. Can't blame the treasurer anymore. Can't blame unless they're part of the board, but can't blame the controller. Can't blame the part-time bookkeeper if something gets missed. Accountability for these whistleblower reports goes all the way up to the top. So just as an example, if someone, someplace is in a position to observe that some type of fraudulent transaction appears to be happening at your organization for whatever reason, they should be able to file a report either confidentially or to a designated person underneath this whistleblower policy. And a big, important consideration, and this is where the architecture of how you design the policy, there is a template in the resources we're gonna send out, but it's also, you have to think about your institution's culture and how information works and flows, because a really critical component of your whistleblower policy is that you have to protect the confidentiality of the reporter. And retaliation is absolutely forbidden and will subject your organization and the people who are responsible for it to intense penalties. So you really need to be set up to take in these reports, investigate them promptly, using either someone who's designated in-house. So for instance, for certain things, I end up being the whistleblowing investigator, right? I take the reports. But what if someone has a concern with something related to my office, right? So we have an alternate site, and those reports also go to our board. And then any resolution of a whistleblower investigation, whether it's, hey, we took a quick look at this, and you know what, this person may have reported in good faith, but when we looked at the totality of the circumstances, it's fine, and we can show, we have the receipts to show everything's fine, right? And you document that resolution, report it to the board, they record it in their audit committee minutes, and then you're all set to go, right? Or there might be some type of corrective action. And you know, people use whistleblowing policies to report all sorts of things, right? It could be even saying that the bylaws are out of compliance. I mean, it could be, you know, there's really no set definition, although it definitely is sort of fraud and abuse of your resources. Okay, so I encourage you, if you don't have one, that's a high priority. There's one little piece I'd like to touch on before we get too much further, and it's something that we have actually dealt with, which is how many of you have access to legal counsel, not who are serving as a trustee or a director, but are actually serving as legal counsel for your organization. So like a pro bono counsel. Okay, okay, but some of you don't, I'm seeing, okay? That is, yes?
I was just gonna say, we don't retain anyone, but we have had representation in cases.
So pro bono? Okay, no, that's fine. There's a danger here. Sometimes trustees, attorneys who are trustees, believe it or not, people become attorneys because they really generally like helping people, and sometimes threatening them, but mostly helping them. And so attorneys on your boards will potentially be very useful, and as a board member, they are obligated to use, you know, all of their usual skill to perform their duty as a director, as a trustee of your organization. But attorneys who are serving as directors should not be serving as counsel. That's a really critical distinction, okay? An attorney should be serving as an attorney. A director has a completely different set of fiduciary duties, and the two should not be mixed. So my warning to you would be, it also can lead to a little bit of a disproportionate power dynamic if you have an attorney who is also a trustee who's serving as legal counsel. They can weigh in with their opinion as an attorney, and they're expected to do so. But they should not be giving legal advice, they should not represent the organization, and they should help find pro bono counsel to get these pieces in place, yes?
Who would you cover in your whistleblower policy?
That is so I will speak thematically rather than, although if anyone wants to look at the Niagara University whistleblower policy, it's at niagara.edu/whistleblowing, so anybody can find it, and it has a tool for anonymous reporting. We actually, I will speak of this a little bit. Previously, ours was more expansive, and now we cover employees and certain other folks, right? But we guarantee that protection for employees. Okay, so does the county have a preference as to who they see?
Well, since most arts organizations have volunteers.
Exactly.
Yeah.
They also have staff.
Yeah.
And they have board members. So this is my opinion, I'm a layperson, I'm not a lawyer, I'm not an accountant. It just appeals to me that I as a volunteer would be covered if I were to be involved with an organization and I saw something amiss and I followed the procedures, whether it was financial or it was misconduct of any kind, that I would be treated in a way that I was protected.
And this is a classic example of institutional culture versus what you might just get from a lawyer. Because a lawyer is going to be very careful and safe and rarely advise a client to do more than they're obligated to do by law. They're going to tell you, use the template policy that comes out of the Charities Bureau, but you may have some very good reasons to think about opening that up. On the other hand, you've now given protection to people that can be quite burdensome, that you don't have to, but there might be some very, very solid reasons for doing that.
Well, and I think this is kind of maybe a good example of where, so sort of policy and practice intersect, right? Especially because we think about what the state law is and sort of the minimum threshold after which you have to have a whistleblower policy. And organizations of that size are more apt to have the core functions done by employees, right? You know, organizations below that size, so some of the ones that are going to be applying for county funding, but, you know, our smaller organizations may have very core functions being done by volunteers. Not necessarily board members, but other volunteers, whether it be bookkeeping, right? Or whether it be legal, obviously, is one that could be, but, you know, even some of the programming of the organization. So there may be some things that in a larger organization would be covered by the whistleblower policy because they're probably going to be done by employees that aren't here. And so that, I think, might be where we're intersecting on this conversation, that for, you know, but as I'm listening to Cole too, describing the whistleblower policy, that kind of speaks to why even smaller organizations might want to have it, right? Because in a smaller shop, you know, you're only dealing with a few people, and so that level of confidentiality, that level of, you know, everyone's comfort level of being able to report something when you're in a small shop as opposed to, you know, a multi-department, you know, hundreds of employees kind of situation, that's probably not a bad thing, right? I mean, that speaks to why you want it.
And one of the things you could look into, if you're worried about the capacity within your organization to receive a complaint, investigate it, and do all the things that you have to do, there are contract services that actually can serve as your reporting place. Now, that does not absolve you of the obligation of your audit committee and or your board, right, to have the ultimate oversight, but they can lend you some capacity, and you know, there's different pricing models for that. It's not just a, you know, one type of organization. Did you have a question?
Well, this is going back to before, not so much about this, but about the legal. Like we have now 3 attorneys on board, but none of them, when we've had even more than that at any given time, because we have about 20 board members now. But we would always have them, like, you know, suggest people. They're all in different firms. I mean, one's a law professor at UV, and the other 2 are like in 2 different firms. So we would just ask them, like, if we needed counsel, we would, you know, say we have to find some. They wouldn't serve as counsel, but we don't retain anyone. Like, we don't have anyone standing by. So you're saying if the need for counsel, find someone else, don't use the one on your board.
Right, exactly. The arrangement,
Yeah,
you said you had some great board members there who were saying, okay, we've identified an issue, I recommend so-and-so.
Yeah.
And maybe they even used, you know, their influence to make sure that the bill wasn't too high or it was pro bono.
Yeah.
That's
I just
perfect.
wanted to clarify that.
Yep, absolutely.
So this is sort of a more nuanced question related to that. So in our board, we have, actually, our secretary is an attorney, and he is the managing partner of a local law firm. And we've been using that law firm as our attorney, and we actually do have that on retainer. And I've been trying to figure out, to understand if that is a conflict of interest.
Wow, okay. Now, so this is being recorded, so I'm gonna think.
They just sent me a new retainage of actually today, that's what I'm thinking about.
So let's parse out the different, there's actually a couple different ways it could be a conflict of interest, and there's a couple different ways that it might not be, right? So first of all, the law firm itself has to ascertain whether or not it has any conflict of interest in serving someone where one of their partners is on the board. And there's no, yes, you know, I can't give black or white answers on that one either, right? That's a complicated analysis. The ethics rules are complex, so there could be a variety of scenarios where that could be a problem, and it might not be a problem, right? It could be a very easy relationship. When it comes to voting on the contract, right, a general rule, I'm not going to speak to the specific situation, because goodness knows who I'm talking about right now. I probably know that Mrs. Buffalo, I'll see them in wagons. So generally, if any board member has an ownership interest, this is where we get to that interest, you know, interested trustees issue, right? If they have an ownership interest in any type of contract that you're voting on, that your board is making a decision on, or that an executive director may be empowered to sign, and a board member is sort of like leaning on them like, Todd, you really want to hire me for this, right? You know, that should be avoided, right? And that can be avoided by simply the board member recusing themselves completely and on the record in the minutes. And there's a process for doing that. And some places that even have scripts for that.
And disclosing on the conflict of interest form.
Exactly.
The yearly form, right? I mean, so, and this may be a good transition from whistleblower to conflict of interest policy and form and such, because, whistleblower, if in fact, you can also have a whistleblower committee, right? If you want to have a separate committee for that, it's the good news is that as long as things are going well, it's not a committee that's meeting regularly, right? But you still have to have good people on it, because if it does have to meet, if a complaint is filed, if something activates that committee, you got to make sure you've got good people on that committee. So it's kind of like making sure your fire extinguisher is up to date, right? I mean, chances are you're never going to use it, but if you do have to use it, you want to make sure that it's working, right?
It's not good enough to have your executive committee handle that, or your audit committee?
You can, yeah. No, you can. I mean, we know there are organizations that have a separate committee for that.
Yeah.
And others that let it be part of the thing. Now, the conflict of interest committee, and the only thing, I'll let Cole get into all of the details on this. That one though, that seems to be a committee sometimes, if again, you have it as its own committee. Some people have the kind of idea about that, and even if you don't have it as its own committee, it's okay, we give out these forms, we collect these forms, we file these forms. Nope, that's not good enough. and that's something that, the independence of directors and the conflict of interest policy and process is another kind of big piece of the Nonprofit Revitalization Act that was really stressed. Because, and keep in mind that when we're talking about the act, it's something that was meant to cover all nonprofits, right? So we think about our nonprofit culturals in Erie County or in Western New York, and they're of a certain size. They don't get larger than a certain size. And so we may look at some of these rules and go, why in the world are they putting all of that on us, right? But hospitals, universities, there are incredibly large nonprofits, not only here, but then certainly when we talk statewide and downstate. And so, the state had to design a policy and an act that was going to cover everybody, right? And that meant the biggest, and then all of us too. So some of this, as you're thinking about why did they put all of this, but most of it connects back to good governance and to things that really are good for us. So on conflict of interest, the key is, a couple of keys are the timing of things, right? That a director coming on to your board is filling out that form, and that form's being reviewed before you vote them onto your board, not afterwards. That's something virtually nobody does, right? Just practically. But that's what you're supposed to be doing, right? And then there's the annual collection of the forms from your existing folks. And a committee, a group of folks is supposed to be looking at that then and reporting back to your board as to where the conflicts are. Now, it is actually okay, and then I'll let you get deeper on this because God knows I can't, but it's okay to have a non-independent director on your board. You can have that. It doesn't mean you gotta kick that person off of your board, but the reporting, the proper activity of that person when it comes to a conflict situation, the awareness of the rest of the board that they're in a conflict situation with that person, all of those are the things that kind of make this work, right? And obviously you don't want to have too many non-independent directors. In fact, there's a cap on how many you can have, I think, but now get that over to you for more detail.
So, and as I was saying, so these are becoming best practices even when they're not requirements. And one thing you might notice is if you are the person who files the certification for your annual insurance renewals, right? There's going to be a lot of things that kind of start to sound like this because insurance carriers are very invested in making sure that their insureds are following these practices as well. So the form should be sent out as prescribed in the bylaws, right? So that's one of those things that should be in the bylaws is the rhythm for doing this. And then there should be some agreed upon process for reviewing them and then archiving. These are not things that should really, get thrown in the corner or shredded. They should be held on to because it's one of those things where it's all good until it's a problem. And then when it's a problem, it can be a big, ugly problem. But many times, conflict of interest isn't so much a conflict of interest as it's an appearance of impropriety, right? And so as long as someone is very careful to get out ahead of it, disclose it, and then recuse themselves on the record from anything involving that, it's not a problem at all, right? It's a very, very simple remedy. And so, people who have to disclose a conflict, or if you have to point one out, and that's a really awkward place for someone in an administrative function to be with a board member. I always think of it as, and Todd's really good about this in my observation, is just kind of leaning forward and reminding and saying, oh, you know what, we have a script for dealing with conflict of interest, just getting out ahead of it, so that you can, declare that properly, as I know you want to do. And then it's just a little reminder, and they can get it done on the minutes, okay? One of the tricks that I have done is when I get the forms, you take a look, you follow up with any disclosures if necessary, and then you should have a process for continual updates, because even if you only ask once a year and a conflict emerges 6 months, someone might not be confident about how to to update it, but if a reminder about updating about any conflicts is there and there's a mechanism, like just email, executive director at such and such. That's a handy way for people should know, right? Your process, your policy should have some type of guidance for updating things in between the annual renewal cycle. I do want to say one last thing on committees, because there's one last committee for those of you who are fortunate enough to have endowments that you should have, and it should be in your bylaws. You'll get there, y'all. Is an investment committee. All right, because there are some things prescribed by the New York Prudent Management of Invested Funds Act that you really NIPMIFA. For those of you who might not remember, NIPMIFA was the topic du jour about 6 years ago when it was first came online. There's some things that you have to have in there when it comes to making decisions about how to spend your endowment, how to invest it, how to secure, how to make a decision about dedicating further funds that maybe didn't come in a restricted manner. So an investment policy and an investment committee is another thing that most likely you should have, unless you want your whole board to function as the investment committee. And there's very precise language about that. So
I had a question relative to audit function. Can it be under the finance committee, or should it be a separate committee?
That's a very interesting question in that it
Because
depends
one
on
is
what
processes,
right.
and the other one is
Right. So, I think you're starting to answer your question, right? So if your finance committee is really about just finding ways to spend the money and balance the budget, and they don't have the time to spend focusing on the institutional controls, right? And reviewing the annual audit, that in some cases will be reviewing the work of the finance committee, depending on how involved those committee members get in the day-to-day decisions just to spend money. It might be best to keep them separate.
okay.
Yes. Let's see. Comment from the county.
This is a touchy subject for me personally, because it drives me crazy. Could you comment about who would collect the conflict of interest forms, and how you would tally how many you have versus how many you should have, and then who would chase people to finish the collection process, so that when everyone in the room applies to Erie County, they can all say they have 100% of the conflict of interest forms, and they are up to date and signed and reviewed, etc.
So that should be in the policy. At my institution, it's actually designated to the general counsel's office for compliance reasons, right? So we've selected an administrator to do that function. Doesn't have to be. So it should be someplace that, without fear, can do the type of checking up and record keeping that's required and make those certifications.
So governance committee?
Pardon?
Governance committee? Governance
committee, audit committee, right? Because your auditors, for those of you who have to do external audits and disclose things in your 990, that's something that your external auditors will most certainly want to see, and sometimes your insurance carrier as well. So the people who routinely interface with your auditors would be a good choice too.
Part two, for donors, is there a conflict of interest for a board member who is a significant donor? Do they have a problem under New York State law as to conflict of interest?
So they are serving on the board and asked to just participate in day-to-day board business and board decision-making, and everybody sitting around the table knows that they just donated $1 million, and the poor lawyer only donated whatever, right? And so could they feel outgunned?
Is that the question?
Is the conflict of interest for the donor who maybe routinely makes large donations?
So
That's what.
New York State law says that there is no conflict.
there
with that
isn't,
donor.
But aren't all our board members supposed to donate?
Right.
No, only your bylaws say that they are supposed to.
No, I don't mean that they're required to.
Wait, I can't hear you.
Sorry, I don't mean that they're required to. I mean that we all want our board members to be donors.
There's
Right.
also a required question on Erie County's
Application.
applications.
Right, and
And
then
if you
that's
say no,
deliberate.
it's got 100%.
So if the policy is that your organization wants the board members, requires the board members to donate, and only 10% do, what are you doing about it? Or if your organization doesn't have that policy, but 100% do year after year after year, yahoo, good for you.
One thing I would say though, is a donor who has given a restricted donation, if they are also a board member and they're voting on the operations of the restricted donation, they should recuse themselves
I would
from
agree with
that,
that.
okay? So, we're getting a little metaphysical, but, yeah.
Yes.
You talked at the beginning about the various kinds of corporation committees and committees of the board. And you talk about the audit committee and the necessity of having one, but some of what's been done by them, and it was already mentioned, could be done by the finance committee, could be done by the governance committee in terms of the conflict of interest or whistleblower policy. So, I mean, what's really the position on this in terms of what is a committee of the board and which ones are required?
Well, one overriding thought is that in your bylaws, how something like your audit is handled needs to be clear. How something like your conflict of interest policy is handled needs to be clear. How something like your whistleblower policy is handled needs to be clear. That's really the overriding thought here, is that whichever model you go with, because look, there's organizations of different size, different numbers of board members, and again, remember that these kinds of functions are all things that would be handled by a committee of the board. And so if you create, 7 of these committees of the board, and you only have a board of 10 people, it's gonna be kind of hard for that to practically function, right? But the point though is that those processes in how those things get dealt with have to be crystal clear. And in some cases, it can be that, for an audit, that your board can designate a committee to handle that, right? But the real idea is that it's got to be clear and it's got to be addressed.
So for example, under New York State law, your board actually could delegate management of the entire endowment fund to the investment committee. And thereby really put that fiduciary responsibility that would typically rest with the entire board on the investment committee, although they still have ultimate accountability, right? So those are some choices, those are some options. The other thing I mentioned is that depending on who your accreditors are, for those of you who might be accredited by an organization, they may have requirements about what they want to see in your bylaws. So it's not just the New York State law, it's not just the federal tax regulations that are governing some of this. There may be some additional things. And they may have a requirement that it be called the Alpha Beta Zeta Committee, right? I don't know. But Todd is exactly right. There are some really key functions, and it's the resolution of conflict of interest, the resolution of whistleblower issues, and I would say also, if you have an endowment, your investment functions that really need to have that kind of very clear accountability, and regardless of what you call it, the committee.
I just want to circle back to the last conversation about if there is a requirement of giving for the board, but not everyone on the board meets that requirement. Now, what if that's not in your bylaws, but that's in a separate, board orientation document or something like that?
So, my personal/legal recommendation actually would be that it not be in the bylaws. But that it be exactly as you described it in an operational document, perhaps even in the letter that you give, to the trustees saying, welcome to our board. During our discussions, we were so excited about your enthusiasm and your agreement to participate in our 100%, contribution, right? And these kids are a really sensitive topic, but you would never want one board member to actually try and fight the actions of another board member based on their donor activity.
Okay.
Right?
Yep.
That to me, that would be a very dangerous thing to set up.
I'm the contrarian on that point. I think it should be in your bylaws, and it should be sensitive to the capacity of the board member's ability to give. So you ask everyone to make a stretch gift in consideration of all their other commitments, but that it is desirable for the board to reach 100% participation.
But don't name a number.
I would never name a number.
Okay.
Right. Yeah, one way, since we've kind of veered into this topic, one way that I've seen it done, and actually that we do it, is to ask our board members to make us one of their top 3 charities, right? And to give at a level that is significant to them, right? So we're being respectful of the fact that we may have a partner in a law firm and someone who may have been recently unemployed. You know, I mean, but they add value to our board in many different ways, because again, you know, it might be professional knowledge or services, it might be connections, there's a lot of reasons for someone to be on your board, but that personal gift is really showing leadership. It's really showing that as the board and the staff are going out and asking others to invest in this organization, that the people who are charged with the leadership of the organization are the first in, so to speak. But we really kind of try to be respectful of that idea that it's significant to you. And, you know, if you're serving on our board, make us one of your top 3. You know, maybe it doesn't mean you have to make us your top, right? You may have been involved in another charity all your life. You may have founded one, for goodness sake, you know, but make it significant. And going along with that, we have a degree of confidentiality with that donation. So it's not like every board member knows what every board member gives, right? I mean, we do keep that confidential, and we, you know, very much make it open that as a board member, you can have a conversation with the chair, you know, about any extenuating circumstances, about any timing. You know, we allow for, you can make it, we want the pledge form right away. We want the pledge form at the annual meeting. But the payment can be by the end of the year, can be quarterly, can be monthly. You know, we can process a rolling donation, you know, lots of different ways to get there. But we at least want that pledge in right away, and then know how to follow it up, and then we can designate, you know, one staff member to sort of make that process or that reminder or whatever.
I just have a follow-up question. Now, let's say there is an extraneous document out there that does say we expect you to give, and maybe perhaps at this level. Would that ever come, would that, if it is an outside document that is not connected to the bylaws specifically, but it is given to every board member, and I don't know, let's just say it's signed, I don't know if it is or not, but let's say it is signed or something like that, would that then be controlling? Could that come into question for
That's another
something?
practical question. So I don't think an organization, I can't conceive of an organization that would sue or use a collection agency to get any promise.
No, I mean about compliance. So if we're talking about Erie County, you know what I mean? Would Erie County say, well, we know you have this document out there?
No.
And you know, one point that this is a really good place for me to make this one point in my notes about making sure that everything agrees with each other, right? And what I mean by that is, so we're talking about a document, and you know, that as opposed to saying give it a level significant to you, says give at this level, right? So let's say it's $1,000, and you've got 10 people on your board. Does your annual budget show that board donations are going to be at a level of $10,000?
Even
Right?
if it's the looking forward budget.
Right, I mean, you know what I'm saying though, but
yeah.
that idea, do
Yeah.
things agree with each other?
Okay.
You know, so in a macro level, it's, you know, what you're saying you're doing in your bylaws and your mission and everything else, does that agree with what you're actually doing? But in a practical level, kind of taking it back and thinking about the fact that this is, you know, a session that's helping you prepare to file grants, right? You know, so there's a question, and you admit this as I'm not sharing a secret, you know, Catherine, you're the first person to say that this is the case, right? There's a question on the Erie County grant saying, when was the last time you updated your bylaws, right? Then, of course, you have to submit your bylaws. And if you say that the last time you updated your bylaws was last year, but you're still referring to your committees as standing and ad hoc, you don't have anything addressing independence of directors, you don't have all the stuff we just talked about, it doesn't match up. Right? Either you made a mistake in the question, or you didn't really update your bylaws, or you did a sloppy job updating, right? I mean, taking it out of that one specific thing, you know, how you answer a narrative question, for instance, on audience numbers, right? We get 100,000 people, right? Then I look at your financials, and earned income was $100,000. Well, that means you were charging everyone $1 to come in, or giving a lot of free tickets out, you know. You say in the narrative, we're experts at social media, and then you look at your Facebook page and you haven't updated in 6 months. Does that match up, right? So I mean, we're talking about, these sorts of issues. The point on this though is that as you move forward on all these issues, and as you go back to your bylaws and make revisions or non-bylaws documents, or whatever you're doing, think about the tendrils of that, right? Think about, does this affect our budget? Does this affect a page on our website? Does this affect that handbook that we're handing out to new board members, right? And just kind of follow it through and make sure that everything ends up in agreement with each other. So that because the sticky part about that is then someone comes upon that one document that you haven't updated and thinks they're doing it the right way because they're looking at this document, but this document's been out of date because it's been replaced by that other document. So it's about kind of, keeping it all together, and that's a good reason to have that kind of handbook prepared because it kind of tells you all of the different places you need to look when you're making these changes, and then kind of thinking about some of the other places to go and make those changes as well. And then that will help you when it comes time for something like this, so that you're not submitting supporting documents that unintentionally, most likely, contradict what you're saying in the forms and in the narrative.
The other, definitely all of your routine filings, your 990, your charities bureau filing, anything like that should be in that compendium. I would also advise that you keep it, if you have a website that is a very important resource to your organization, your website domain name registry should be in there as well, because your organization should own your domain name. And one of the things I have seen at different organizations is that, some very nice person registered the domain name in 1997, like Mike Smith, 1997, and later on, Mike Smith still owns the domain name of, your organization, but he's nowhere to be seen because he's moved to Chicago or whatever, right? So it's just making sure that those, again, everything matches up. So check out your domain name ownership. Make sure you've recorded, when is that domain name going to, expire, right? Also your trademarks. And then for those of you who may have valuable intellectual property that you've generated, and by that I refer mostly to copyrights, although some of you might have patentable business practices. But your trademarks and your copyrights, if they're important enough that your organization really relies on being able to, stop anyone else from using them, really your logo, your name, and any critical document, make sure they're registered with the U.S. Patent and Trademark Office or with the Copyright Office. In order to get a cease and desist in the Western District of New York, if somebody starts using hall walls, right? I like hall walls, I'll just call my business hall walls, right?
We actually have that case happening.
Oh my gosh, I'm so sorry.
We don't see it as a problem, but it's like some young artist in another city started a place called Hall Wall Street.
Oh, wow.
And they say right on their stuff, like, we're named in honor of the original Hall Walls, you know what I mean? So we see it as a positive thing. We don't see it as a problem, but.
Interesting.
So just one little piece, generically speaking, if you do let someone else use your name, make sure you've actually given them express written permission, because when another person comes along and they want to call their perhaps nefarious business also Hall Walls, right, for whatever it is they're filming, you might want to stop that person, but the fact that you didn't take any protective action or license it, and you don't have to charge any money. You can just say, hey, we're so glad you have permission so long as you continue to be doing that great stuff you're doing, right? So you might want to talk to one of your lawyers about that, just to make sure that it's written, because otherwise it could work against you later.
If there's we have an individual who started the domain name, excuse me, but the organization is listed.
That's the owner?
Yes.
Oh, that's good.
Well, nothing on it says owner. I've looked at this document so many times. Nothing says owner. It says contact, responsible party, organization.
So you might want to just make sure that the ownership is actually listed in the name of your organization. And I'll just, actually before I worked at Niagara, I was in private practice, and I represented a business who was a family business, and one person had registered the domain name. Long story short, he got cut out of the family business, and he took the domain with him, right? Very disruptive. And we ended up having to sue to get it back, and we were able to do that, but, you know, they paid me, and it was expensive and disruptive. And it was because it had actually been registered in the name of the family member, right, instead of the name of the corporation. So just, you know, those are those little things, and those are little things, frankly, again, that I look at when I'm seeing, you know, does this entity really have its stuff together? So just a little detail to check.
Hearing all this, I'm coming from a very, very small organization, one that actually does fall under the $25,000 limit. And I'm quickly realizing that as a volunteer, I may be in over my head on this. Do you have suggestions for places to secure said legal counsel?
Do you want to hit that one first?
I mean, first off, in terms of sort of getting you some of the way there, you know, as Cole said, we've got some templates that we're going to share with you. We've got some things, you know, for you to look at. All of them need to be vetted through your organization, right? And make sure that they're right for you. And it's always a good idea to have some sort of legal, you know, put the finishing touches on it before your board approves something. In terms of actual legal counsel, that's a good question. And there are some volunteer lawyers groups, but
There's some volunteer lawyers for the arts in town. It's a small group. The Erie County Bar's Intellectual Property Committee, and the Erie County Bar has a referral service. And then sometimes I think actually just networking with your people here, right? And just saying, because depending on what your organization does, there are probably attorneys out there who will find it very interesting. They might want to promote that they're doing it, you know, pro bono for their own publicity. There might be a lot of reasons that they would be willing to help out. So yeah, reach out to your colleagues. You'll find something.
I want to make sure that in the next couple of minutes, we cover just a couple of other things relatively quickly. The idea of a governance committee was mentioned earlier. And in previous years, some of the things that we've done sessions on with Erie County have been about evaluations, especially like board self-evaluation or executive director evaluation. And those are things, those, you know, we've already said a couple of things that something like a governance committee might do. Those are a couple other things that a governance committee might do in terms of at least shepherding the process through. And so, you know, I actually personally am a big fan of having a governance committee because governance is sort of one of the pillars of what a board needs to be interested in. So to have a group of your board members who are kind of razor focused on that is really a nice thing. Not to mention the fact that the chair of your governance committee is going to get very versed in the operations of your board, and that's like another excellent training ground for a future officer of your board, is the chair of your governance committee, or really any member of your governance committee. So things like running the process of a board self-evaluation, where you're sort of sending out a form, and again, we have templates for this that you then can customize to your own needs. Kind of talking about two things. Number one, as a board member, how do you feel you're doing in your service to the organization, serving on a board, right? And then secondly, how do you feel the board as an entity is doing? And the reason those are asked separately is because they could be very different answers, right? It could be, I think I'm knocking it out of the park as a board member, but boy, this board's a mess, right? Or just the opposite. This is actually a really good board, but I'm struggling to find my place on it, right? And a lot of times we ask those questions, you know, anonymously. So it can be just a simple, you know, poll set up online, a Survey Monkey or whatever, you know, and then the governance committee can kind of gather that information and present it back. You know, and that's a way then to lead into what sort of professional development or training your board might want to undertake for itself in the next year, what things it wants to think about. And again, those are things you can kind of come back to ASI with and say, we're interested in having a board training for our board on this topic. And either I'll come in and do it, or I'll find you someone who's more versed in that topic, and we can kind of follow up from there. The executive director evaluation, again, the same kind of thing. They can shepherd the process with input from all of the board members, right? It's not just that committee deciding whether or not the ED did a good job, but they're at least taking care of the process for you. That's a place where something like the conflict of interest process can happen. So in the old days, like that might have been kind of, to some extent, the nominations committee. So that idea of vetting new directors or trustees can come through that committee to some extent. but in a thoughtful way, right? So it's not the month before your annual meeting, and oh boy, 3 people are term limiting off, we better go get 3 more board members. That's the worst way to do it, right? So the idea of having a committee that, again, is thinking about this and projecting forward, how many vacancies do we have? How many are we creating in the next year or 2 or 3 because of term limits? You know, what are our needs? Assessing, again, that board self-evaluation and tying it in. And then officer recruitment, you know, so we elect our officers. And how many boards right now has the board president sitting up there going, all right, so who wants to replace me next year, right? And either, A, you actually really do, but you're not gonna tell them that, or B, nobody wants to because it's like, well, all right, this guy doesn't really wanna leave, so I'm not gonna come up and say, well, I want him to leave, right? By having sort of another group that's ushering that through, it sometimes can lead to a much more honest conversation about people who might be interested in stepping up. Or even if they're not interested in stepping up themselves, a concern about an officer or an idea about, wow, I don't want to do it, but you know, Cole would be amazing for that. Like, have you talked to her? You know, and so it really kind of rounds out and also lets your executive committee and your officers kind of focus on some other things too. So it's a really nice, I think, layer to bring into your board.
So that was a really nice positive note that I wish we did, but we do have to talk about dissolution clauses.
Actually, before we talk about that, I just want to mention I want to do a cheap plug for one of the brochures that you saw. You know, a lot of what we're talking about came out of the Nonprofit Revitalization Act. So it came out of the Attorney General's office when they identified that there were some things that had to be done differently, right? Concurrent to that, they actually also created something called Charity Strong, which is now its own organization. And that was the idea that, all right, if we're putting all these additional things on nonprofits, we should probably give them a resource by which they can grow their boards or better their boards. And so this brochure here is for the thing called Charity Strong. And ASI, we're pleased to serve on the Western New York Steering Committee for it. It can do 2 things. The first thing is it can provide some educational resources for our Director's U program. There's a basic core course called like Good Properties of a Good Board or something like that. It's a 45-minute video that you can take in like 10-minute segments or watch the whole thing. And that's available for anyone. You can ask your board members to go on there and just register and watch it, or you can ask them to do it together as a board and then discuss it. And you know, there's a lot of other resources too. At least half of them are free, some are paid. Then there's, what the heck is that thing called? Onboard. And Onboard is kind of a matchmaking service. So concurrent to groups like us in the United Way, making sure that organizations that might need board members know about this. We have our colleagues at like the Buffalo Niagara Partnership, Leadership Niagara, Leadership Buffalo, going and recruiting businesses who might be interested in placing some of their folks onto boards, getting their folks signed up for this. And so through Onboard, you can create a profile, see what your needs are for boards, and help start to find you know, potential matches. And then of course you have to go through your process of deciding whether they're right for you. They have to decide whether you're right for them, and that's another place where having that governance committee can come in. But all of that's good, and they ask though that anyone that's going to be part of that matchmaking process, that their current board members go through that 45-minute training, so that at the very least, when you get that great new board member coming on to your existing board, they're all kind of in the same mindset about what that good board service looks like. So we're not bringing on, you know, someone who doesn't know what they're getting into onto a good board, or we're not bringing on a really talented new board member onto a board that's not thinking about what it means to be a good board. So please look at this. It's free for organizations to use. So, you know, it's not the end-all be-all, but it's a great resource, and there are hundreds of people signed up looking for board opportunities right now.
So,
it's like match time.
I was just going to say, the board dating service, and are stuck with the entire board and they're already using it. There's 2 places that I would say, if you're sitting there going, oh geez, you know, this is all great stuff, but you know, I have a board that really likes the way they do things. They're not terribly interested in, you know, myself or another person telling them that we have to tidy things up or correct some processes. The Charities Bureau really does have excellent documentation, and I encourage you, there's a really good pamphlet on the link that we're going to send you called Right from the Start. okay? And it's a really good, I think it's about 15 pages, and it really takes people through the fundamentals. And there's another one in there about financial controls. So, my bottom line is, you really don't have to put yourself in a position where you're teaching them. You can simply provide the information, and a really great technique is to take a board member who gets it and ask them to do a short presentation. It's like a little board therapy. I mean, you can certainly bring in an attorney, an outsider, a trainer to do board boot camp, but sometimes just a little gentle therapy works out. And then,
I like how our last topic, so we told you about all of these ways to strengthen your board, strengthen your organization. Now we're gonna talk about dissolution for a minute.
Here's
So-
what happens at the
yeah,
Yeah, so
right.
if all else fails.
Right, so right from the beginning, one of the things you should be thinking about is, right, if this does not work out for whatever reason, where will the assets of this entity go, right? And that is a question, typically the Attorney General's office in New York State is going to oversee what's called a wind-up, a corporate wind-up, where an organization, for, again, whatever reason, says, that's it, we give up, right? And those assets are being transferred. And this is supposed to give guidance and make sure that that wind-up plan is kind of ready to hit the ground running. And it's really, finding an order, you don't have to name a specific organization. It's not like, listing who gets the comic books in the will or something like that, right? But it does have to be another organization, similarly aligned, within Erie County. And you certainly can designate people, but that gets a little risky because if they disappear, then you have a problem. So I don't know if the county has a thought on what they like to see when it comes to dissolution.
Just that there, it is mentioned at the very end of the bylaws, if anyone read the story about the Mark Twain statue at the Elton Square building, that was the result of an organization that tried very hard to create an entity. It didn't work. The woman sadly got very sick and died, but they had to have a dissolution plan, and there really wasn't one, and it ended up going on and on for like 15 years, and battles and so on. So the good news is the statue is there, and education programs are happening at this museum, but that's just one example of why you might think that this is overkill by the county, but it is a piece of good governance, a piece of good planning, and if we get to a period, I hope never again, of scarce resources for the sector, there might be mergers, there might be consolidations, there might be organizations that don't make it. We also know that more than half the organizations that apply to the county, their annual operating budgets are less than $200,000 a year, so that's pretty small organizations, and they're sort of like family businesses. And so when those founders or the first decade or two, they run out of steam, can't find the board members, they just say, uncle.
And actually, it could be, it was getting a little depressing, but it could be that two organizations decide that they have some redundancies and they might want to merge to be a stronger organization. And again, the Charities Bureau has excellent documentation when you're thinking about a merger, because that's when a lot of that due diligence I was talking about, you want to know, do they own their website? How much debt do they have? What contracts are they pulling, are they obligated under? All those kinds of things, because once you go down the road too much, it can get very, very ugly. So.
Yeah, at the last meeting, I thought it didn't have to be mentioned in our bylaws.
Did you say that?
I did say that.
Okay. It would be preferable.
But it will be,
Just
we just to make sure that
wanted-
our bylaws are not just thrown together.
We really wanted a radar screen.
Yes.
So that it's sort of from a full life cycle for the organization.
It might even be in your founding document, your articles or your charter.
Yes, your charter
Right?
absolutely
It really
has
should
it.
be. Yeah, it absolutely should. Yeah, if it doesn't, it needs to.
We definitely do not have that. I'm thinking that a lot of organizations have buildings, which is a big asset. We have an endowment, it's not really only asset of value, but I can see that could present a problem. So how much do you have to say at this point, when you're not contemplating it, but you have an asset like an endowment? And again, our endowment compared to others, so museums or whatever, is small, but it's, considerable for our size. So how much do you have to say to have a dissolution policy? Or where do you find that information?
Right, so the Attorney General's, the guidance is right there.
So Ed, you might say something like a similar arts organization based in Buffalo, New York, that has an educational mission, and if you were focusing on young kids or seniors, or so things that are very specific to what you're trying to accomplish, you might put into that statement without naming
Right.
XYZ organization.
And do you say that the board, like the last board, will make that decision?
Yes. And usually it names the minimum number of board members you must have.
Right.
There are organizations that get to the point where they have less than their required minimum, which is usually 3 or 5, but they can get down to 1 person. So just giving direction. It's really about giving direction without naming the place.
Right.
I would point out, by the way, you also have a valuable trademark, so.
Oh, yeah.
So that is worth money, that could be actually appraised and found to be an asset that was transferable. So there's some other assets to think about.
So the statute does have a provision on dissolution in the statute, correct? So you're saying, in addition, we should have a plan of dissolution in our bylaws?
No, not a plan.
Yeah, not a plan. It doesn't have to be like a step-by-step. It's a general theme.
So you want to make a statement in the bylaws?
If the corporation were to wind up, the assets would be disposed of in conjunction with the Attorney General's office and board leadership to a similarly aligned organization.
Right.
It doesn't even have to be within Western New York. It could be a highly unique thing. And then you could think about designating a specific place. It's just that's risky. By your charter potentially or your bylaws.
And also given how hard it is for organizations to find their own documents.
Right.
That's why it's nice to have something mentioned in the bylaws, because those do tend to be found more regularly than not.
We will keep taking questions for people who want to stay with us, but I wanted to make sure we're cognizant of the time we said we were going to end. So before I end, as Cole mentioned, we will send out a follow-up in terms of some of those links and documents. From ASI, we will also send you a survey asking you what you thought about all of this. Please be kind. No, I'm kidding. Be honest. If you want to be kind, that's fine. And also, I want to make sure that we thank Caldwell's for hosting this tonight and Squeaky Wheel for taping this. And Parrish, you had something to add.
Yeah, we ran out of copies of some of Cole's presentation notes, and so just can we make sure that I have everybody's email so that I can send that to everybody?
And by the way, for folks who have not met her, this is Parrish from Team ASI, and also please meet Mark from Team ASI, who we just brought on last week to be our new associate on the fiscal side of things, which means we are now offering some bookkeeping services and fiscal sponsorship. And that will be my last cheap plug for the evening.
Is that what people just saw?
Yes, that's my nickname. Yes.
Okay.
Anyway, so for those who need to go, thank you for coming. For those who want to ask any additional questions, we'll keep going for another few minutes.